Good morning, and thank you very much for joining us today. I'm Lisa Smith, Senior Research Fellow in Business and Human Rights at BICL, and I want to give thanks for the co-organization of this event to my colleagues Ivano Alonia, BICL's Arthur Watts Research Fellow in Environmental and Climate Change Law, and Professor Duncan Fairgrieve, the Director of BICL's Product Liability Forum. I also want to thank our speakers for joining us today, as well as everyone joining in the audience. The questions of the responsibilities of companies in the fight against climate emergency has perhaps never been as pressing as now, and is set to gain even more momentum as we see increasing legislative initiatives in the area. At BICL, we have looked into the topic from various angles in the past few years, including a January 2020 conference on climate change litigation and a webinar series 1 year ago in September 2020 on human rights due diligence for climate change impacts. Today, we are looking at existing and potential future accountability mechanisms for climate change, corporate climate change impacts, including but also extending beyond litigation and even legal liability to other frameworks that hold some form of legal consequences for companies in meeting certain climate change responsibilities. It is an attempt at trying to map and analyze the existing mechanisms, the anticipated forthcoming mechanisms, as well as potential innovative or future uses of existing mechanisms in order to identify the gaps where new legal mechanisms are necessary, the shortcomings in existing mechanisms, particularly when it comes to prevention or preventative remedies and proactive problem solving, and lessons we could learn from comparative areas. These legal frameworks have often been developing in silos in different areas of law, and we believe that it's only by taking stock of what we have that we can identify coherent responses to the climate crisis for companies, governments, and all stakeholders that represent people and the planet. So it's now my pleasure to welcome our panelists, and please also do see the link in the chat for the list of the speakers' bios. Our first speaker today is Catherine Hyam. Catherine is a policy analyst and the coordinator of the Climate Change Laws of the World project at the Grantham Research Institute on Climate Change and the Environment at LSE. Thank you so much for joining us, Catherine. Could you set the scene for us with an overview of the current legal and policy landscape relating to corporate climate change accountability?
Hi, yes, and thank you so much for inviting me to be a part of this panel. I'm very excited for the rest of today's discussion. So I'm just going to try and share my screen to begin with. Can you see that in slide in the right format? Great. So as Lisa said, I'm going to share a very quick overview of the global legislation and policy landscape, and then we'll hear more about various aspects of this from the other speakers. So to begin with, I'll quickly introduce the Climate Change Laws of the World platform, which I coordinate and which informs my perspective on this issue. I'm then going to talk a bit about key developments in the global landscape, and I'm sure I won't cover all of them because there is a lot going on. And then finally, I'm going to talk about 3 examples of accountability mechanisms that we see in climate change framework legislation. And I'll talk a bit about why I've chosen those later. So the Climate Change Laws of the World database is a global database tracking climate change laws, policies, and litigation from around the world. We run this in partnership with colleagues from the Sabin Center for Climate Change Law at Columbia University. And we currently have 2,324 climate change laws and policies in the database. But when I did a search for corporate accountability in our search function on the database, I only got 5 hits. Now that of course doesn't mean that corporate accountability isn't being addressed in climate change law and policy, but I think it does tell us something quite interesting about the way that this issue has been addressed from multiple different perspectives and dimensions, and corporate accountability isn't necessarily the framing that a lot of policies are being given. I should also say we define climate change laws and policies quite narrowly when we're deciding what should be included in the database. Only laws and policies which contain provisions which are explicitly framed as responses to climate change are included. So some of the key developments in the global landscape then, I've bucketed these into kind of three distinct areas. Firstly, you have the pink line here, which is international instruments, both binding international legal agreements like the Paris Agreement and soft law instruments like the OECD guidelines and the UN Guiding Principles on Business and Human Rights. I'm not really going to talk about those, but of course they inform what we see happening at the law and policy level at the national within national systems. Then you have this sort of darker blue group of laws, which I have categorized as kind of climate explicit laws. So the kinds of laws that would meet the definition we use for CCLW and which are explicitly addressing corporate accountability in some way. And then you have this sort of lighter blue group of laws on the right-hand side, and those are legal regimes or legislation that is not framed as explicitly climate relevant, but which is nonetheless being used by climate litigators and others to start to regulate corporate behavior in this area. And so I think we'll hear a lot more from Lydia about some of the way in which these types of regimes, particularly civil liability regimes, have been used. And I won't touch on that in great detail. So to look a little bit more at these kind of climate explicit corporate accountability mechanisms, the first group, which I've put kind of across the others, is climate change framework laws. And these are often, flagship laws. They're multi-sectoral, overarching in nature, and they set kind of systemic strategic priorities for a country's response to climate change. And typically when we think about these, we normally think about them as creating accountability for government action. But I've recently been looking at these with a few colleagues, and we found that more than half of these laws also contain provisions that are relevant to private sector accountability. And so the examples I'll talk about in a second are all pulled from that. Sitting below those then, we have a number of specific types of climate sort of relevant or climate explicit legislation. We have emissions trading schemes and sectoral regulation. And I have to say, I wouldn't originally have thought of emissions trading schemes as a corporate accountability mechanism for climate change. I would have put them in a different policy sort of bucket of relevant policy instruments. But I was recently in a webinar with Mike Gerard and a couple of other people who were discussing this. And of course, the purpose of these emissions trading schemes is really to require companies that are subject to the schemes to act within certain parameters on climate change. And in many ways, they have the strongest accountability mechanisms for companies that fail to do that. Now, of course, the emissions trading scheme is, those accountability mechanisms are only as strong as the emissions trading scheme. So if too many allowances have been given to companies under the emissions trading scheme, then you're unlikely to really see the kind of action that we would want at the company level. But nonetheless, an interesting one to think about. Another kind of critical area, which we also see manifesting in climate change framework laws, is legislation and policy on disclosure and reporting. And I'm sure that's something that we'll get into in a bit of detail later today. And then finally, we have corporate due diligence obligations. And you'll see I've put them in a slightly different color to the other categories here. And that's because, as far as I'm aware, current mandatory due diligence laws, none of them are climate explicit, but I think that's about to change if the proposed European legislation on corporate due diligence passes in its current form. And so I think we can really see this as kind of an emerging frontier on this issue. So to talk quickly then about a couple of examples. So I mentioned emissions trading schemes, and one of the things that's quite interesting is that a number of climate change framework laws, particularly passed by European countries, include within them provisions aimed at implementing the EU directive creating the EU ETS. And it's worth noting, as I said, that this is a kind of direct regulatory regime, quite strong in many ways, and is also paired with kind of naming and shaming provisions. So companies that breach their obligations under the EU ETS are supposed to have their names and details published in registries by member states. Now, this maybe hasn't been used in great detail in the past, but I think it's an interesting example nonetheless. We also see, as I said, climate change framework laws that implement kind of disclosure obligations on private parties. The first of these was the French Energy Transition Law that was passed in 2015. We've also seen similar provisions adopted in Spain's recently passed framework law under Title VII of that law. And Article 173 of the French law imposes obligations on listed companies, banks and credit providers, and institutional investors, requiring them to report climate-related information. And if we look at the obligations on institutional investors, for example, that includes ESG criteria, integration of climate risks into reporting, and also questions about alignment of emissions reduction targets with national and international goals. And of course, it's interesting that these target not just companies, but also investors and banks and credit providers, because of course, the idea behind some of these kinds of provisions is that they might mobilize incentives relating to the cost of capital and other issues, even if they don't have kind of hard sanctions written into them. And then the final example that I'll touch on that comes from climate change framework laws is a more recent development that we've seen with kind of strong sanctions-based accountability regimes being incorporated into these laws. And the example on the screen comes from Uganda's National Climate Change Act 2021. It kind of builds on a similar provision from Kenya's 2016 Act, but this one is more explicit. And you'll see that it's actually framed as a law, or a section on litigation on climate change, and it creates broad standing for anybody to bring an action against a private entity whose action or emissions threatens or is likely to threaten efforts towards adaptation to or mitigation of climate change. Now, we haven't seen any cases brought under this provision yet because it's so new, but I think this could be an interesting kind of next frontier in this issue of corporate accountability for climate change. So I'll stop there. It was a bit of a whistle-stop tour through various different things. And as I said, I'm hoping some of our next panelists will get into some of those issues in more detail. Thank you.
Thank you so much, Catherine. That was the perfect overview of the direction that we were hoping to go in today. So I just also wanted to remind all participants, we have a Q&A box. Please put any questions in there, any comments. We might not have a lot of time for verbal responses at the end, but if you put your questions in there, then at least there's a possibility that some of the panelists might be able to address them in writing. And we do hope to have a little bit of time if we can at the end. So we now turn to Lydia Omukuyung. Lydia is Research Fellow at the Institute of Public Law and Political Science of the University of Graz, and is also an attorney at the Kenyan Bar, where she previously worked as a litigation counsel in Nairobi, representing government and non-governmental entities in national and regional courts within East Africa, and advised subnational governments in Kenya on mainstreaming climate change consideration into sectoral legislations. Lydia, thank you so much for joining us today. Your work focuses comparatively on climate change litigation and on the legal aspects of consumption-based climate policies. Could you share with us some of the most interesting developments in these areas, particularly relating to corporate climate change litigation? The floor is yours. Thank you, Lydia.
Thank you so much, Liz. And yeah, sure, I can share that. And thank you for inviting me for this session. So I will just go ahead and try to share my screen. Yeah, there we go. Okay, so thank you very much. So what I'll do is just to provide an overview, of the trends and development of climate cases that seek to hold corporates accountable or liable for climate-related impacts. And yeah, just to start off, I'd just like to mention that we have seen quite an increase in cases that seek to hold corporations liable or accountable for the impacts of climate change. And if you can see the graph on the left-hand side, It just shows that most of the cases have been from the US, but we also see an increase in other regions, especially after 2015. And what are the claimants seeking in some of these cases? First of all, they seek damages for either loss of properties due to the climate change impacts, and because these companies or corporations are contributing to climate change. Or for instance, you find cities, municipalities in the US are seeking for the cost of adaptation. So these are the kind of damages that claimants are seeking. And then we also see cases where claimants are actually seeking that companies should reduce their emissions. And an example is the Shell case that was recently decided in Netherlands. And then we also see claimants asking for disclosure of climate-related risk, particularly the risk of climate change impacts of business, impacts of climate change on operations of companies, and even the strategies that companies are putting in place to address the risks that are presented by climate change. And just to provide some brief background, if you look at the climate litigation in the early 2000s up to around 2014, most of it were filed in the US, as I mentioned before, and they are mostly based on federal common law causes of action, such as public nuisance, private nuisance, trespass, and negligence, among others. And these are examples such as Kivalina. We have the state of California, state of Connecticut. Most of them were filed by cities in the US. But then in addition to tort, we also see in the early 2000s, there are some inquiries into company disclosure of climate change risk, including financial risk from climate change regulation or litigation, and companies' greenhouse gas emissions and how it affects their financial exposure. And most of these cases were mostly in New York, and this is because New York has this Martin's Act that grants the Attorney General quite expansive powers to conduct investigations of securities investigations of security fraud and bring civil or criminal actions against certain alleged violators. So we see a lot of cases were based in New York. And just to get back into common law causes of action, we see that most of these cases that relied on federal common law were actually dismissed, and mainly because of displacement, where they say that greenhouse gas is regulated by the Clean Air Act, and therefore the federal common law cannot be relied on, or also the political question doctrine or foreign policy preemption and the typical standing. So these were some of the challenges that stood on the way for federal common law causes of action, and most of them were dismissed. And then if we come to post-2014, we see a continued use of common law, but then the strategy is changing in that the plaintiffs are now filing these cases under state law as opposed to federal common law. If you look at, for instance, in Auckland, which was filed under the California state law, and although it was dismissed for political reasons and because it was still heard by a federal judge. And then also, if you look at Baltimore, it was also filed under a state law, including Maryland's Consumer Protection Act. So one may ask, why is the strategy now changing to state law as opposed to federal common law? This is because we see that the position of federal district courts regarding separation of powers is quite clear, and they have been dismissing cases because of the political question doctrine, because of foreign policy preemption. But then plaintiffs are hoping that the state courts might take a different approach, especially on the issue of separation of powers, because we see some states in the US, such as California, have often declined to follow the federal jurisprudence on the issue of separation of powers. So this could provide some window of opportunities, and probably the state courts might determine these issues differently. And that's why the plaintiffs are actually trying to file these cases under state law as opposed to federal common law, in addition to other reasons. If we go beyond the US, we see that claimants in continental Europe are relying on their civil codes, such as the Liu versus RWE that relies on the German Civil Code, specifically the provision that requires a disturber to remove interference or disturbance. And while this was dismissed by the lower court because of causation reason, the appellate court has now partly accepted causation argument and said that partial causation one could still be held liable for partial causation, and now the case is at the evidentiary stage. The other one is also the recent Shell case, which relies on the unwritten standard of care under also the Dutch Civil Code. And based on this unwritten standard of care, the court ordered Shell to reduce its emissions by 45% by 2030. So we see claimants are also relying on civil law, especially in the continental Europe. Other than that, we also see human rights obligations playing a role in holding corporations accountable and liable. And just the starting point is the carbon measures inquiries, where the inquiry was whether carbon measures can be held accountable for human rights implications for climate change. And while the Commission concluded that legal responsibility for climate change is not covered by current international human rights law, it noted that the onus is on individual countries to pass strong legislation and also for courts to establish liability. But more importantly, it also noted that fossil fuel companies have an obligation to respect human rights under the UN principles on business and human rights. And we see that indeed, some countries have developed human rights and environment due diligence legislation, such as the French duty of vigilance law, which are now being used in court to seek accountability against companies. And the French duty of vigilance law, this is a mandatory human rights and environmental due diligence legislation. And it's already forming a basis for litigation, where there's the case against Total in France, which is challenging the Tilenga oil project that is in Uganda and Tanzania, mainly because of failure to assess the project's threat to human rights and environment. So this is still ongoing. The case has been, the court has decided that it should be determined by the commercial court. And we're waiting to see how this would go. But I think it actually presents quite a strong opportunity, or a good opportunity for courts to define corporate climate due diligence and climate standards of care, especially under the French law. Human rights have also been used to interpret civil liability obligations of corporations. And here we look at the Shell case, where the court found that Shell's obligation to reduce emissions comes from the unwritten standard of care. So while the court noted that human rights cannot directly be invoked against Shell, it factored in human rights in interpreting or defining what standard of care should be. And for this, the court followed not only human rights treaties, that is the European Convention of Human Rights or the ICCPR, but it was also guided by soft law, such as the UN Guiding Principles, the OECD guidelines on multinational enterprises. So we see here human rights are not being directly invoked against corporations, but then they're being used to define the civil liabilities or the standard of care. Other than human rights, we also see securities and financial regulations, as well as corporate regimes being used by courts, by claimants to seek liability. And one of this is the securities fraud, security and equity fraud, where this is again, I take an example from New York again, because of this New York Martin Act that they have. And here, claimants or states assert that companies are misleading consumers about the role of their products, the role the products play in causing climate change, and that they're misleading investors about the material climate-driven risk to its business. And other than securities fraud, we also see some claims by shareholders against pension and investment funds, or also cases arising from financial investment in the fossil fuel industry. And yes, from the fossil fuel industry. And I take the example from the Mark McAvee case versus Rest, where it was also a shareholder claim against a fund for failing to incorporate climate risk into their decision-making. And particularly, he was seeking for more information on the climate risk and how Rest was planning to manage the risks that are presented by climate change. And this case did not proceed to the end because parties reached a settlement. And actually, what was quite interesting is that Rest agreed that its trustees have a duty to manage the financial risks of climate change. So this is quite an interesting for the pension fund itself to agree to this. And just to finish up, one thing that is also becoming quite interesting in recent litigation is that we see plaintiffs from the global south suing companies in the global north against the activities in the global south, and or against the activities either of subsidiaries in the global south or generally their worldwide activities. And this has been based on, for instance, the due diligence legislation, which is the French one, which is now allowing companies to be held liable for activities of subsidiaries. And the French law allows victims to hold French-based parent companies liable for abuses committed by their subsidiary companies abroad. But then other than that, we see examples from environmental law, where the duty of care is now being used to hold parent companies liable for the activities of their subsidiaries. And one of the main reasons has been because the parent companies set some policy or supervises, or they even exercise some degree of control and management. And this has been used to hold parent companies liable for the activities of their subsidiaries. And what does this mean for climate litigation? I think these are going to provide some leeway for parent companies to be held liable. And particularly, it would be interesting just to look at the cumulative emissions, because usually when you look at emissions of one company or a subsidiary, for instance, in the global south, the emissions might be too little for them to be held liable. And sometimes they bring this argument of the drop in the ocean argument. But then if you look at the whole group, including the parent company, then the emissions become more, and it's even easier to hold them liable. So I consider this could be quite an interesting way to be able to look at a group of companies rather than individuals. And we see that even though in the Shell case, it was not, an issue was not about the parent and subsidiaries, one thing that the court mentioned, that due to Shell's policy setting influence over the Shell group, then they could be held responsible. And also that the far-reaching control and influence of Shell then provides this responsibility for Shell to reduce, for Royal Dutch Shell to reduce global emissions. So in conclusion, we see there's an increase of cases where new strategies are being used. Although common law and civil law continues to form bulk of the cases, the human rights obligations are now also being used to interpret civil liabilities, or also the human rights due diligence regulations that are in place. And finally, we see also securities and financial regulations being used to hold corporate liable. And finally, quite something that is going, I think, that we learn lessons from the environmental law that could now be open floodgates for climate litigation against transnational companies is transnational tort litigation, which I think provides quite an opportunity. Yeah, thank you.
Thank you so much, Lydia, for this really helpful comparative overview of the trends in the litigation. Our next speaker is Lisa Benjamin, and Lisa is an assistant professor at the Lewis and Clark Law School in Portland, Oregon, where it is a very nightly hour at the moment. So thank you so much, Lisa, for joining us today. She's also a member of the Compliance Committee of the United Nations Framework Convention on Climate Change. Lisa, could you speak to us about also some of the recent litigation, but also some developments that extend beyond litigation, including relating to the SEC's contemplated rules and on shareholder activism? Thank you so much.
Yeah, thank you. Good morning, everybody. It's a pleasure to be here. So thank you for the invitation. I'm just going to share my slides with you. So I'm going to give a little overview of what's happening in the United States. And thank you, Lydia. That was an excellent platform for me to start with. I just want to mention, going back in time a little bit, as Lydia has mentioned, some of the history of the litigation in the United States. And it is vast. It's the jurisdiction that has by far the most climate litigation cases. And I wanted to just highlight two things in what is traditionally called the first wave of litigation in the United States. One was that there was a successful regulatory claim by the state of Massachusetts against the Environmental Protection Agency, and that interpreted the Clean Air Act to say that the government, actually the EPA in particular, did have the authority to regulate greenhouse gases. However, some of the other cases, as Lydia had pointed out, in particular the American Electric Power case at the Supreme Court, said that, look, federal common law is going to be preempted by federal statutes like the Clean Air Act. And so that's not going to be successful. And that first wave happened in the early 2000s and really sets the scene for the second wave, which has really been a lot of claims by states and cities, predominantly against corporations, although there is a case, the Juliana case, which is against the United States, which I'm not going to focus on. But these were states like New York, cities like Oakland, that sued a vast number of corporations for a couple of things. And so the second wave, I try to divide it. There's like 3 waves, I think, in the second wave. There have been a lot of different trends that are going on. And so the first sort of wave and the second wave were really for adaptation costs. And these were brought partly under, as Lydia had said, federal common law. One case was brought by businesses, the fishermen in California, brought a case against corporations for loss of crab stocks from fishing. There's also a couple of cases about failure to adapt by some oil and gas companies, and I'll focus on one of those. And as Lydia has also mentioned, there's some securities-based litigation, and now we see, I think, a third wave that is securities and also consumer fraud, and that's mainly state-based. And so at the moment in the second wave, a lot of the jurisdictional fighting is going on. So what is happening really is that the defendants, so corporations, largely oil and gas corporations, are saying, look, we want to remove this to federal court. And the reason we want to move it to federal court is because these have to do with emissions in the ambient air, they're interstate, or this is a foreign affairs issue, so the political doctrine question, or navigable waters of the United States is involved, outer continental shelf. Look, these are all federal issues. And as Lydia said, some of these arguments have been successful, in particular in New York and the Oakland cases. Courts have said, if anything cries out for a federal solution, it's climate change. And so this is a federal issue and it's preempted, federal common law is preempted by the Clean Air Act. But some of the later cases, like the Baltimore decision, have gone to the Supreme Court, and the Baltimore decision and the Fourth Circuit said, actually, we're going to keep this in state court. We're not going to move it to federal court, which is an interesting decision. And it went up to the Supreme Court on very narrow grounds. And so what some of the corporations said was that, we produce oil and gas on the request of the federal government. We have permits, either the military or some kind of federal officer is involved. That makes us a federal officer. It was a really narrow ground of appeal to the Supreme Court. And the Supreme Court did say, Fourth Circuit, you have to relook at this, the grounds upon which you removed it for the federal officer removal statute. But the Supreme Court said, look, we don't want to get involved in the other removal grounds. We don't want to get involved in this sort of debate between whether this is a federal issue or a state issue. So you all work it out in the lower courts. So that was a really interesting Baltimore decision. I'll go back to the Fourth Circuit and we'll see what's happening. But as of last week, so I have to put a date on this because so much happens in the US, it's really hard to keep up. And I'm just highlighting a couple of these. In the second wave, we have, I think, 3 potential waves of this. So the first wave, we have these older cases that failed on federal common law displacement. We have some of the newer cases that are trying to avoid the federal displacement and just say, look, this is a state issue. And all of these in the first wave, we're still stuck in this sort of jurisdiction issue. The second wave are newer claims that highlight different things like derivatives, shareholder derivatives, breach of fiduciary duties, some consumer deception issues. And part of these are investigations, as Lydia had mentioned, by the Martin Act, which was dismissed in New York. Massachusetts is claiming the same thing. That actually is going to stay in state court for the moment. There's a couple of cases in states like Texas. So in the Fentress case, there's a class action by pension fund members that failed in Texas for securities issues and misleading investors. But there's a Ramirez case also in Texas where this is talking about Exxon's writing down its reserves and that shareholders were unhappy about this. And this has not been dismissed, so this is still ongoing. There's also a shareholder derivative suit against Exxon. And so there's actually some cases that haven't been dismissed yet in the second wave, so we'll see where they go. And I think the third wave of the second wave is some of this consumer deception, but greenwashing, basically. This is focusing on these net zero targets and advertisements made by fossil fuel corporations. And in particular, we'll see what happens with the Minnesota case, but the Minnesota Attorney General is suing, saying, look, we're not going to focus at all on your production of fossil fuels. We don't want to get involved in federal issues like interstate pollution. We're really focusing on what you told consumers in Minnesota. And that has actually been remanded back to state court, so that will stay in state court. There's a Beyond Pesticides case, again, focusing on clean energy ads, and that's been stayed because the Attorney General is actually passing legislation. And then the case I want to focus on just for a few minutes is the Conservation Law Foundation. So this is a case which is like a failure to adapt case. It's brought under federal statutes like the Clean Water Act and RCRA, which is a Resource Conservation and Recovery Act, against Exxon for its oil storage and distribution terminals in Massachusetts. And the case is saying that, Exxon, you have these permits expired. These allow you under the national system to have some discharges into the nearby river, but you far and away exceeded those permit authorities because of climate change. Because of extra flooding, you have actually exceeded your permits. The previous decision was said, Exxon's applied for new permits. Let's wait for the EPA to issue them. And the U.S. Court of Appeal in July said, actually, no, we're going to vacate the stay order, actually decide this case, because even if new permits are issued, that doesn't cure the discharges that happened in the past. And there are potentially thousands of dollars of penalties owed per day for these kinds of violations. And so it'll be a really interesting case to watch because it's a traditional federal permit case. So in the last few minutes, I really want to focus on the new administration and what's happening sort of beyond litigation. So in May this year, there was an executive order on climate-related financial risk, which is a really important executive order from the Biden administration. And what it focuses on is federal agencies, financial federal agencies, taking what is called a whole of government approach to climate-related financial risk. And so this is motivating some of the actions out of some of the larger federal agencies, including the Treasury Secretary. And also part of it, I think, is actually really important, but under-examined is the procurement mandate. So the president has told the federal acquisition regulations that they are requiring major federal suppliers to disclose emissions and set science-based reduction targets. And that covers not just public suppliers, but private suppliers. And you can imagine that one of the largest private suppliers to the US government is oil and gas companies, particularly to the military. And federal agencies have to consider this executive order when they're making these procurement decisions. So procurement in the US government is huge. It involves a lot of entities. And so it'll be interesting to see what happens. In addition, the SEC had in 2010 issued guidelines for disclosure of climate change risk. Those guidelines were rarely enforced by the SEC. And because of the last election, the SEC is an independent agency, but 3 out of the 5 commissioners are now appointed by President Biden. And because of this change in the control of the commission at the SEC, there's now much more of an impetus to require disclosures on climate change from issuers. So what the SEC has said recently was that they welcomed public comments on this. It's not a proposed rule yet, but this idea of mandating climate change disclosures by issuers regulated by the SEC, so public companies. And there have been a number of comments on this. A couple of issuers are, of course, unhappy about this, but institutional investors are very, very keen on this going forward. We anticipate that in the near future, the SEC will actually issue rules on this. They have specifically said that we're going to enforce the guidelines a lot more than we have. And in particular, last week, I think, the SEC published what they call a sample letter to companies requiring disclosure under the guidance. And so there's going to be a lot more activity by the SEC on this front. In addition, some of you might have heard that there's some proposals on infrastructure and the budget reconciliation in the US. And one of the proposals by the Democrats is called the Clean Electricity Performance Program. This still has a long way to go before it's actually can pass even the House committee. But what this does is provide uplift payments to utilities for use of renewable energy or clean energy. And how that is defined is particularly important because it excludes natural gas. And so it really focuses on renewables themselves and on natural gas. And then finally, there have been a number of activities in the past year, really. So Blackrock is one of the largest institutional investors in the United States. They issued a statement to CEOs saying, we are really concerned about climate change. We want you to actually take action on that. And if you don't, we as institutional investors we're going to make decisions about whether we keep our money with you. Blackrock began to be a little bit criticized by that because they didn't seem to be doing anything about the statement. And a year later, last summer, Engine Number One is an activist hedge fund that actually was supported by BlackRock in this really surprising initiative that said, look, Exxon, we're not happy about what you're doing about climate change. We are actually going to propose some directors to your board. And this was actually, this activist approach was accepted by the shareholders at Exxon, which was a huge surprise. And Chevron faced a similar but less comprehensive proposal. And if you want to have a look at Engine Number One's approach, this is it's a really interesting read about re-energizing Exxon. And then very finally, this came out last week. There was a leaked, I think it was Greenpeace UK, leaked a video of an interview that they did with an executive by Exxon, basically saying, we have supported financially and been part of groups that have spread disinformation about climate change. The Oversight Committee in the House has requested that oil and gas majors come and testify before Congress in late October. I suspect this is going to be patterned on some of the tobacco testimony, so it'll be really interesting to see what happens. So my last slide, there's a lot going on in the US. There's not just litigation, there's actually disclosure regimes that we think we'll see in the SEC, so that will affect the regulatory license to operate. We have some Democratic proposals around at least financial incentives. Litigation, we really don't know what's going to happen if some of these cases stay in state court. They might be successful on the consumer deception. The economic license to operate for firms is under pressure as well because of the SEC and a lot of investor pressure. There will probably be some rules around methane capture, I think, for oil and gas companies in the United States. And then finally, I think some of these testimonies in the House, the social license to operate is under a lot of pressure as well for corporations in the United States. And this is actually being compounded by some of these consumer deception fraud cases. It's really easy for consumers to see that, that is a very public-facing litigation. And then finally, my small plug for this, if any of you haven't read it, this is the second edition came out on these principles. I think they're really innovative and interesting, and I highly recommend that you have a look at them. So thank you very much.
Thank you so much, Lisa. Really, really helpful updates and exciting times, and also the very interesting link between the laws and then actually the corporate responses and what is actually the end game that we would like to see from these laws. So thank you so much for that. Our next speaker is Francesco Quarta, an associate professor of private law and comparative law at the Bologna Business School at the University of Bologna. He has previously served as an arbitrator for the Banking and Financial Ombudsman instituted by the Bank of Italy as an alternative dispute resolution mechanism. Francesco, could you provide us with a brief overview of current developments, particularly in the area of environmental, social, and governance, or ESG requirements in the banking and financial services sector? Thank you so much.
Yeah, thank you very much. Lisa, just a second ago, spoke about the US President's executive order on climate-related financial disclosure obligation. I will briefly speak about the regulatory agenda on this side of the Atlantic Ocean. But I will do that in just a few minutes. I would like to start by saying that a systematic approach to this emergency requires really a multidisciplinary team effort, and a systemic emergency such as this one requires a systemic change. So the basic point I'd like to make in my presentation today is that finance, as we know it, needs to change as well. If we think we can keep without significant amendments the current philosophy that governs the financial markets, I think I have a sense that the road towards our climate goals, our climate targets will become more and more difficult, more and more steep. But let me share now the Article 2 of the Paris Agreement. It says that the overall agreement aims to strengthen the global response to the threat of climate change by, among other things, making finance flows consistent with a pathway towards low greenhouse gas emissions and climate resilient development. So this clearly is a call for everyone, public sector and private sector, to ensure that the consistency of the extant financial techniques of the existing financial markets architecture with sustainable development goals. So what have we done as a banking, as a financial system since the Paris Agreement? Let me skip to the next slide. So this is a slide witnessing what the private sector, the banking and financial sector, has done since 2015. The graph here shows the total funding of fossil fuels by international banks since the Paris Accord. So there is a clear and constant increase in investment of fossil fuels initiatives. And here on the bottom left of the screen, you can see that the world's top 60 banks pump $3.8 trillion into fossil fuels since Paris Accord. So all this reveals clearly that the private sector cannot be left alone. So if we really want to meet our climate goals, well, it's no longer time for greed-driven capitalism. Many authors and commentators have declared that the problem is capitalism itself. No, it's not. The problem is financial capitalism. The problem is techno-capitalism, the financialization of the entire economy. So the 2008 financial crisis was not a matter of wrong estimates, of wrong forecasts only. It was essentially the byproduct of a system whose main actors had no interest in what was going to happen in the real economy. The driving factor of financial capitalism is cashing as much money as possible through maximization of short-term profit. So as long as there is hope for even a slight markup, okay, so keep pushing on, let the ball roll, and then who cares in whose hands the ball is eventually going to explode. So the current climate emergency, this is the point, requires a sweeping change in the very conception of the markets architecture. We can't afford, sticking to the metaphor, that the ball explodes in the hands of future generations. So this is it. Do we want to mobilize private capital and redirect it towards socially and environmentally beneficial initiatives? Well, private capitals are essentials, of course, but the rules of the game can no longer be the same. For example, new models of corporations can help in the process. So corporate finance can be guided into a new pathway. Let me show what we can. Can you see this? Yeah. Okay. So there are different models, corporate types, corporate models: low profit liability companies, flexible purpose corporations, blended value enterprises, public benefit companies. So why is it important to change to look into these different structures, corporate structures, because the fiduciary duties, because the officers, the directors' duties, according to these different goals, can be approached from a different angle. So not only corporations need to change, but also the financial instruments. And here I can provide a few examples of hybrid financial instruments which can be employed in the context of the pursuit of the net zero emission goals. So, for example, social impact bonds or green bonds, for what matters, they're structured more or less the same. But what is the most intriguing part of this is the measurement. How do we measure impact? How do we measure the actual achievement of the stated goals? So this is the great bet on which, as I will show in a few seconds, the European regulator is actually working. And then the last two examples, I think they're particularly interesting from our perspective. So green loans, the traditional loan contract, can be structured in such a way as to highlight a special purpose. And I will show you here. Let me make it bigger. Here, very briefly, you can see it now on full screen. So here is an example of a mining company in Canada, in North America. This was, yeah. So so the company has access to a sustainability-linked credit facility. How does it work? The company has access to such a credit facility, and the facility works as follows. If the company manages to achieve some ESG targets, then it has access to a reduced cost of financing. And this is linked, as you can see on the bottom. If the company achieves the highest rating, a AAA rating, for example, it will experience a reduction of 0.5% interest on its draw balances. So sustainability-linked loans. It could be a way to encourage sustainability, okay, in some traditionally controversial sectors, such as the mining sectors. And then, of course, we can also speak about the possibility to resort to alternative investments, because the global challenge requires the involvement of as many people as possible. So we should also take into account the possibility to include also Islamic finance, because Islamic finance, and this was recognized by the official newspaper of the Vatican State in 2009, Islamic finance has a potential to shift the focus from an interest-based finance into a product, into a actual goal-oriented finance. So let me briefly going straight to the conclusion. One of the main problems is how do we follow the actual impact. How do we keep impacts under control? So the question is, and I will very briefly go to the conclusion. Who grades? Who rates what? Because this is the big challenge ahead of us in securities regulation. So here in this slide, and then you can also take a look at later. On this slide, I summarized that there are over 160 raters globally. So our need for standardization is put in jeopardy by this great variety of examples. So I think this is particularly interesting. Users generally do not carry out any formal verification of the ratings. Hence, the process is seen as a black box. So that's why, and I skip to the next slide, which is the second to last slide. That's why the EU regulator is working towards an actual oversight of this market, because there is a market for ESG ratings with companies competing with one, competing towards the first place in the market. So on April 2021, the Commission published delegated acts to complement the EU taxonomy regulation to include financial disclosure obligation, more stringent disclosure obligation on service providers and issuers. So the last thing I would like to highlight is the recent communication by the EU Commission last July 21, a strategy for financing the transition to a sustainable economy. So by 2023, which could be too late, the Commission should issue regulation to ensure that relevant ESG, environmental, social, and governance risks are systematically captured in credit ratings and rating outlooks in a transparent manner. So the idea is to improve ESG ratings reliability and comparability. I read it from the news this morning that the Italian SEC, Consob, has just closed its the first part of its overarching investigation on greenwashing in the financial market. So we will soon see what comes next. So I will stop here, and I'll open for more questions. And thank you for your attention.
Thank you so much, Francesco, also for covering so many very important points in a short time. Sorry. So our next speaker is Ariane Griffith. Ariane is a senior campaigner on corporate accountability at Global Witness, where she leads on research and policy for the EU Corporate Accountability Campaign. Ariane is also an attorney and a researcher and a former colleague at Bickle. So thank you so much for joining us, Ariane. Could you share with us your thoughts on the relevance of the ongoing legislative considerations at European level, and particularly the relevance that these legal mechanisms may have for corporate accountability and liability, respectively?
Of course, thanks, Lisa. And it's always good to join a Bickle event, of course. So thanks for having me and for convening this. As you just touched on, I think the starting point of the discussion we're having today is around different models of corporate accountability, ones that exist already and ones that we can develop in the future. And I'll cover 3 points in my 10 minutes, which is briefly reflecting, as Lisa just mentioned, on the potential for corporate accountability under the EU Sustainable Corporate Governance Initiative. Considering then why a cross-sectoral approach is important for corporate accountability in the context of climate change, and then briefly discussing greenwashing as one of the strategies used by companies, which undermines efforts at accountability, and also kind of considering why it's important to hold them accountable for that. So before I get into it, I thought that it would also be worth mentioning that we're talking about three key concepts, or have three concepts at play here. Those of accountability, liability, and access to justice, which are all distinct but related. And to offer what is perhaps an oversimplification, I think of liability as a form of accountability, and access to justice is a route to liability. And in fact, liability being something that has a very close relationship to access to justice, and perhaps one as evidence of the other, or counterparts, if you will. But of the three of them, accountability is obviously, or quite clearly, the broadest. And it includes access to justice and includes liability, but is definitely broader than both of them, as other panelists have talked about already. Corporate accountability includes procurement requirements that Lisa mentioned, for example, that the US government is looking at now, and ESG requirements, shareholder activism, civil society campaigns. And it's important, of course, that they all feature, all three of these concepts feature in an appropriate response to negative impacts that companies have on the climate. So to get into my first point on the EU Sustainable Corporate Governance Initiative, as a starting point, I thought it would be worth noting that the European Parliament report on this file explicitly referred to corporate due diligence and corporate accountability in its title. And there's definitely potential for the forthcoming directive to create accountability for negative human rights and environmental impacts, including climate impacts. And there, in my view, at least 5 elements of the legislation that will help to ensure that it's not only about due diligence, and instead also introduces elements of corporate accountability. So the first of these is the fact that it will introduce a binding requirement on companies and standards that we can hold them accountable on in the broader sense. Secondly, that it will create liability mechanisms, which at a minimum should include civil and administrative liability. Thirdly, that it will create access to justice opportunities for victims in EU courts, so that accountability can be real and tangible for the people who are affected by business activities. Fourthly, by creating regulatory oversight for companies. And fifthly, by going beyond the basics. So by applying to all sectors, by going beyond tier 1 suppliers, by going beyond scope 1 emissions, and by going beyond harms that the businesses cause, and including other relationships to harm, which in the framework of the UNGPs and the OECD guidelines, will look at extending to harms that the company has caused, contributed to, or is directly linked to through its business relationships. That, of course, is if we get it right. But get the legislation right, that is. But the cross-sectoral nature of the laws is particularly important in considering accountability for climate impacts. And Francesco discussed the importance of taking on the financial sector in this effort. And an example of this is the decision of the Dutch NCP, the Dutch National Contact Point, in the complaint brought by Oxfam, Banktrack, Friends of the Earth Netherlands, Milieudefensie, and Greenpeace Netherlands against ING Bank. And there we saw that the bank accepted that its biggest climate impact was in its financing activity, that is to say, its indirect emission. And when we refer to making finance flows consistent with international plans for climate action, this is what we're talking about. We found similar patterns in Global Witness investigations of European banks financing some of the most destructive agribusinesses that are funding. The banks are funding some of the most destructive agribusinesses that are flattening what we know are climate critical forests, so the Amazon forest in the Congo Basin and in Papua New Guinea. And so it's important that finance as a sector is included in the legislation and in improving corporate accountability for climate impacts more generally. But in the complaint against ING Bank, the NCP clarified that the Paris Agreement can and should translate into concrete obligations for business. And what we need to see is more of that going forward, embedding the standards agreed in the Paris Agreement into domestic legal frameworks, including obligations for companies. We have a similar issue with the fossil fuel industry as well, in that companies reporting on their climate impacts and setting climate-related targets very often don't cover their Scope 3 emissions. And by Scope 3 emissions, we're talking here about the indirect emissions occurring in their value chain. So the problem with fossil fuel companies not including their Scope 3 emissions is that Scope 3 emissions account for around 85% of that industry's overall emissions, which means a target that doesn't take those into account doesn't allow for meaningful accountability on the climate, on the company's climate impacts. And what makes it worse is that in virtually every case, these companies are relying on carbon sequestration, they're relying on CCS, on carbon capture and storage, and on offsetting to reach these targets. And I won't go into to CCS and BECS and carbon sequestration, but offsets are a particularly egregious problem in the climate debate and how companies are using them, because they're put forward as a solution, as a way of reaching our net zero targets. And so on, but they're used to allow polluting companies to continue emitting greenhouse gases instead of reducing their emissions. And there's several other issues with offsets around quality and quantity, and of course, the necessary, really fraught discussion around the environmental justice impacts and the human rights implications of taking large areas of land in the global south to offset emissions in the global north. But as I said, offsets are presumed to hold a lot of promise, which is, which brings me to my last point on greenwashing. Because some of the biggest polluters are also very interested in making a concerted effort to look like they're doing their part. So we have fossil fuel companies appear to be greening, rebranding themselves as leaders on renewables, as energy companies rather than oil and gas companies. And when we take a closer look at their plans or their capital expenditure, for example, it tells a very different story. And so one of the underestimated impacts of greenwashing is that it distracts everyone. It creates this false sense of security that in turn delays effective action on climate. And this is dangerous because the science tells us that we literally do not have time to waste. That companies use clever, well-placed, well-crafted ads and creative, unrealistic, unevidenced targets to tell their consumers, to tell our policymakers, our legislators, and the rest of us that they're paying attention and they're getting it under control. So briefly on ads, in the UK, the Advertising Standards Authority will only respond to complaints that are misleading, inaccurate, or false. And the fact that it's harmful to the environment or that that the result will be harmful to the environment or the climate is not itself sufficient as grounds for the ASA to get involved. And there's actually analysis as well by Ad-Free Cities, UK-based Ad-Free Cities, that show that the ASA only investigates 22% of the complaints that they receive and upholds 2% of those. So there are huge gaps here. You can also only have an advert removed. There's no other sanction for the company. The regulator, in this case, doesn't fine companies that are in breach of their rules, which means ultimately that the stakes are low for companies and the reward is high because they continue to enjoy a social license to operate. And what it means altogether is that it's very difficult to hold companies accountable for greenwashing. Client Earth, as many people will know, brought a complaint before the UK NCP against BP for their advertising in 2019. And it was on the basis that it was misleading to the public. But in response to that, the company withdrew the ads, which of course evidences the pressure that was put on them. But even so, we know that even if the NCP had gotten to issuing a decision against the company, this would have been a non-binding decision. So my last point is that just to briefly mention that we also have increasingly attention being paid to the companies that are behind these adverts. So the advertising agencies, the PR firms, and so on, that are really behind these greenwashing campaigns. And that's important because they're an essential part of making the campaigns as successful and slick as they are. But it's even more difficult to hold them accountable, particularly when we think about hard accountability, when we think about legal corporate accountability. So this is something we'll be working on at Global Witness going forward. So in case anyone is interested, please do get in touch. That's a plug. And I'll leave it there. We need measures that require changes in business responses, starting with the requirement to measure, to report on scope 1, 2, and 3 emissions, and including non-negotiable reductions in absolute emissions, which in the near term, which would be critical. But legislation like the one that's planned in the EU has the potential to increase corporate accountability for climate impacts by directly addressing it and coupling this due diligence requirement with other opportunities for accountability. Thanks. I'll leave it there.
Thank you so much for Ariane for your, as always, very thought-provoking and impactful points. And I should just mention, we are unlikely to have any time for verbal responses to the Q&A, but please do put questions in the chat box, and potentially the speakers could answer them in writing. Our next speaker is Ina Ebert, and she's an expert for liability and insurance law at Munich Re. Ina is also a professor of law at the University of Kiel and a member of the advisory board of the Institute for Robot Law at the University of Würzburg, and vice chairwoman of the supervisory board of the European Center for Tort and Insurance Law in Vienna. Ina, could you speak to us today about climate liability and litigation from a liability insurer's perspective?
Yes, I will. Thank you very much. My topic is, what is the role of insurers in all of this, and liability and accountability for climate change? So next slide, please. First of all, a short reality check. Could you switch? Perfect. First of all, obviously, we do see a lot of litigation going on, but the vast majority of all this litigation is not about liability. The vast, as we have heard already by the other speakers, there's a lot about this. And even if you do come to some kind of liability, most of this is not relevant for insurance, simply for the fact that it's about intentional actions, and intentional actions are usually not covered under insurance, at least not under liability insurance. Think of GHG emissions, for instance, or think of greenwashing. Those would not be covered. But of course, this might change since the regulation is getting stricter. Next slide, please. So what have we seen? What kind of claims have we seen? And which could be relevant for the insurance industry? We've seen strategic claims, we've seen claims for regulatory action or injunctive relief. Those two are at least not directly relevant for the insurance industry. What is or could be relevant are claims for damages or abatement. So those who claim some kind of losses, this could be relevant if they are covered under some kind of policy. If you go to the next slide, please. So how could insurers be involved? First of all, insurers are corporations like any other corporation as well. So anything they do is also relevant for some kind of litigation and could be part of some kind of litigation. They could be defendants in some kind of litigation of some kind of shareholder actions. Then obviously insurers, and especially reinsurers, are big time investors. So the question is whether to invest in some kind of fossil fuel related industry or not, or which limits to watch out for in this regard. And then the second part is how they are involved as insurers by insuring something. And obviously insurers have always played a big part in insuring climate change related risks, like for instance, wildfires, floods, or hurricanes. All those have a certain connection to climate change, and obviously property insurers do play a very important role in insuring these risks. However, today we are talking about liability insurers, and the question is, should they also play a role in this? But definitely they have to ask themselves, do they want, for instance, to insure any kind of fossil fuel related risks. We have seen this discussion in the coal connection, and obviously at one point in time, other fossil fuels will also be the point of discussion. Next slide, please. Now let's have a closer look at how some of these claims could affect some kind of lines of business in the insurance industry. GHG emissions as such, direct climate change liability, as we've seen in some of those cases that were mentioned, could be covered under general liability or environmental liability. However, GHG emissions are nothing that happens sudden and accidental. It's something companies do on purpose, and therefore normally there would not be any coverage. Different idea is failure to adapt or to consider consequences of climate change. This could be covered under professional indemnity, for instance, under errors and omissions, or under general liability. And this, of course, is core business of liability insurers. With greenwashing and consumer fraud, it's a bit more complicated. Greenwashing is something that's usually done intentionally, but it's not always possible to prove that it's done intentionally. It's not impossible if you look, for instance, at the Dieselgate litigation, but it is difficult. And if it's done negligently, then it could be covered under general liability, professional indemnity, environmental, or D&O policies. And finally, there is a failure to report, disclose, consider, comply otherwise with regulation. And we have a lot of regulation already, and we will have even more in the future. And definitely that's a typical case that of a loss that's covered under D&O insurance. Next slide, please. However, it's not as easy as it might seem. I've already mentioned some of the coverage issues that might arise. One is that usually it is an intentional act in that context, and this is not what insurers consider an occurrence, because normally that's something happening sudden and accidental. And if you do it intentionally, if you do produce greenhouse gas emissions, or if you do somehow cheat your consumers, then this is nothing for your insurance coverage. The other idea is that the last point, damages versus abatement measures, is that often we have public nuisance-based claims. Public nuisance is not only intentional, but it also leads to awards that are not so much damages award, but that are supposed to do something good in the future for society, to somehow improve the societal situation. And these are not losses that are normally covered. Could be covered theoretically, but normally are not covered. So even if there's liability, that doesn't always mean liability insurers are involved. Next slide, please. So what does it all mean? We've also heard some of this. One thing is that definitely all those net zero and so on targets and claims that we see now by just about any company on Earth will come back to you at one point in time and also be involved in some kind of liability scenarios, because it seems hard to believe that all companies who promise to be climate friendly now and reach certain goals within a certain time frame will do so. The other thing is that good risk management becomes even more important, because there are so many issues of compliance with regulation of some sort that insurers should watch out for this. In a nutshell, what is the role of insurers in that context? Well, first of all, the role of insurers could be to incentivize climate-friendly actors and actions simply by making them insurable and by investing in those kind of activities. The second idea is that insurers can support, enable, and finance and ensure companies do try to act the right way, but might fail at one point in time negligently. And third point, insurers can also deter climate unfriendly activities simply by not investing in them, simply by making them uninsurable, which is what they try to do, or at least by raising the bar for risk management activities, by raising the bar in regard to awareness of climate change consequences, something like that. So in a nutshell, that would be the role of insurers, and I try to hand over for the last few minutes to the last speaker so that he has a chance to say something, because time runs out. Thank you.
Thank you so much, Ina, and apologies for the tight timing today. I will hand over directly to Mads Andenas, our last speaker today, Professor of Law at the University of Oslo and also former Director of BICL. Thank you so much, Mads, for being here. Could you speak to us about the role of state-owned oil companies and wealth funds, and if you have any time left, also about the implications of the EU Energy Charter? Thank you so much.
Well, many thanks, Lisa. What seminar, what a topic, and what speakers. It's such a privilege to have been listening to all of this, and I know my place, of course, so I'll make myself extremely and unusually brief. And well, when you think about state-owned companies, you think that they are particularly well regulated, and they are subject to the pressures of the market, and they are subject to the pressures of the state and public policy. And when you look a bit into the matter, you find that they're subject to neither, which is a bit surprising. Now, in Europe, of course, we had every reason, or everywhere in the world, I expect, to be very pleased with the Dutch Supreme Court case, the Milieudefensie versus and Shell, and then the European Supreme Court, the Supreme Courts generally, the courts in Europe look at one another. So it is hugely, hugely important. But Shell, of course, is not a state-owned company. Now, it's not that far away, by the way. You know, if you know London well, you have 3 generations of headquarters of Shell. You know, the London establishment, and if you move over to the Netherlands, you'll find that it left a similar imprint. But it's a private company, which then makes it very different, for instance, from the Norwegian Equinor. And being state-owned creates quasi-immunities. As we know, they are not covered by any state immunity in a public international law sense, but in a practical sense, you often get a particularly protected position, which also other oil companies like to use. Then if there's something particularly objectionable, they like the state-owned company to go first. Well, you would have thought then that all the panoply of reporting requirements, as we heard about, and particularly what follows from the European Green Deal and the EU taxonomy, well, that's, by the way, focusing on the financial sector. And of course, these state-owned companies often do not require private finance. They are in such a strong financial position. So what, for instance, the Norwegian authorities have done, which they say, we are a state owner, but we want these companies to operate in the market. And then they have minority private shareholders. And then the state authorities say, we step back and leave the governance in terms of the operations, etc., very much to the control of the market through these private owners, the minority shareholders. They, of course, will say, well, we're not that concerned about the risk profile of the company because it's state-owned, and we'll be helped out by the state if there's any problems arising. So you get the worst of all worlds, no state control and no real market control. So, well, what then about the oil fund? So let me take you to the Norwegian oil fund then. So that's, of course, accumulation of wealth derived from oil extraction over the last 30 years. But how is this compared to other oil funds? Well, actually, it transfers money to the state currently used to subsidize directly brown investments, including oil exploration in the Arctic through a rich set of instruments, including state aid, tax relief. So also then here you got an oil fund who's is a main culprit. You know, not only that you have accumulated the wealth from oil extraction, but you actually then funding oil extraction, which today is difficult to fund through private finance. So what should then be the reply here? Well, it's for these seminars like this to focus on, well, the normal, the political process at the European level, at the national level, but also to make use of what happens then in the case of, and I'll just use one more minute, if that's all right, happens in the EU at an international level, and of course in the other cases that come up before courts, such as the Dutch Shell case, but also before the European Court of Human Rights right now, you have the case of the Portuguese youths, and there's a sister case from Norway, 2 complaints relating to the decision by the Norwegian authorities to give an oil exploration license in the Arctic Sea. And there, the European Court of Human Rights, 2 complaints on that, and I launched one of them on behalf of the Norwegian grandparents' climate action, very appropriate accompanying action to the Portuguese youth, I think. But here, the European Court, in its earlier rounds, said to the Portuguese youths, well, we're looking very seriously into this, obviously. So they had a list of questions to the parties, and the Portuguese youths had cited the ECHR, the European Convention on Human Rights, Article 3 on health interventions on the person, and Article 8, privacy. And the court said, well, what about Article 3. What about Article 2, which is about life? So that was the court's initiative. We may get a court decision which establishes state liability. And of course, then the oil companies and the oil fund will say, well, we're not a state. Well, indeed they are, because they are state-owned or completely state-controlled in different ways. These are assets which anybody who has a claim against, well, the fund or the Norwegian state oil company, but also the Norwegian state, hopefully sanctioned, a claim hopefully sanctioned as a human rights violation by the European Court of Human Rights. They should then make claims. Civil society should make clear that there is a basis here, discuss as we do now, and then encourage actions to be brought in any jurisdiction where any of these bodies, the oil company or the oil fund, hold assets. And if that starts and if that develops, well, then it most certainly will affect both the oil fund and the state-owned oil company. And the point is, you don't have to win the cases. You create a level of uncertainty which will affect corporate behavior. And that's the first thing that these actions do. If they then eventually succeed, fantastic. They will have huge impact on corporate behavior, but also on policy and the actions then of states at a national level, and for that matter, at the European level. Thank you, Lisa. That's all I had time for.
Thank you so much for wrapping all of that up into perfect timing, and those very important points relating to the relationship between the state-owned and the privately owned companies. Thank you so much to all our speakers. Really so much food for thought for us to take this forward. And it was a real pleasure to hear from you. Hopefully we'll continue to have these conversations. And thank you so much to everyone who joined from elsewhere. We should be able to have the recording of the event on our BICL website soon. Thank you so much. Have a good day. Bye.